Hi, thank you for that introduction, and welcome to all of you. We're really happy that you joined us today. Good morning or good afternoon, depending on where you are. And thanks again for joining us. Thank you in advance to my two co-presenters, Marlon Abbott and Stas Zakharenko. We'll do some intros in a moment. Just a reminder that you can submit questions during the presentation. We're planning a dedicated Q&A session at the end of the presentation, so we may not answer those during the presentation, but we will do our best to get to your questions at the end of the presentation. And now let me introduce our other speakers. Happy to be joined today by my colleague, Marlon Abbott, and one of my primary outside counsel, Stas Zakharenko from our law firm, GTC Law Group. Quick note about me. My name is Rone. I'm the general counsel for IntelAgree. I joined the company in 2021. I've spent about 20 years working for various SaaS companies here in the US. And with that, I'll introduce Marlon Abbott.
Hello, everyone. My name is Marlon Abbott. I am the Director of Information Security for IntelAgree. My career spanned over 25 years, everything from a United States Navy information warfare officer to working for many global companies from utility, critical infrastructure, and also for SaaS support as well across governance, risk, compliance. I'll pass it off to Stas.
Thank you, Marlon. I'm Stas Zakharenko. I'm a principal at GTC Law Group. We're a technology-focused boutique law firm. Prior to that, I spent about 20 years in-house, including at Amazon, at Audible, where I was general counsel, and at Netflix, where I was an attorney focused on AI issues. And now I work with Lee on closely on AI issues as one of my great clients.
Thanks again to both of you for joining us. So our theme for today, staying on the right side of AI and contract management. We wanted to try and narrow the focus a little bit when considering this topic. So what we've done is we've broken it into three, hopefully easily recognizable buckets: duties, policies, and standards. So what are your duties as both an attorney and a non-attorney, or an attorney supervising non-attorneys when using generative AI and agentic AI? We all know that they're reshaping the practice of law and the legal team, outside counsel and inside counsel, rapidly. Policies, not whether or not to adopt policies about generative or agentic AI, but how to adopt them and keep them compliant. And then standards, we're fortunate to have Marlon here with us to talk about industry standards with those acronyms that you're probably familiar with, like SOC and NIST and ISO. To kind of set the stage for our discussion of those three buckets of activities, what are the core ethical duties that are affected by AI-driven change? We wanted to kind of pause for a moment and make sure that we're all kind of on the same page when it comes to generative versus agentic AI. If we were having this webinar a couple of years ago, we probably would not be talking about agentic AI unless we were developers or software engineers, because the big hit back then was generative AI. We all probably remember where we were and what we were doing the day we first heard about ChatGPT in late 2024. That was generative AI. Of course, it's still around, but now agentic AI is on the top of everyone's list of things to do, test, learn about. But AI has been around in your legal tech platforms and your tech stack for years before that. Lots of people called it machine learning back in those days. What's the difference between the two? Because there is a significant difference between generative AI and agentic AI. Most of you know about generative AI. You've used it in your workplace and perhaps also at home. AI produces output, which could be a draft of a document or a red line or something like that based on your input, a contract in this case, let's say a non-disclosure agreement, and your prompt, review this non-disclosure agreement against my template, and your request for output, which is produce a red line. The output would be the proposed red line. That's kind of where generative AI stops, but agentic AI can take over. Most attorneys, especially outside counsel, have been using agentic AI now for over a year, maybe a year and a half. AI in agentic form can act for you. We'll talk about the difference between stateless and stateful AI, agentic AI, but another way to think of it is that in terms of that NDA we talked about, agentic AI can actually route that NDA for approval and maybe even go ahead and email it back to the counterparty to see what they think about it. So that definitely implies some of the rules we're going to talk about, especially the rule of competence and the rule of the supervisory rule. Stateless versus stateful is important more and more agentic AI is becoming stateful, or at least the AI vendors out there are giving you the ability to make your agentic AI stateful. Stateless AI takes a contract and maybe your playbook, and just changes 5 clauses because that's what you told it to do. But it goes ahead and does that. It doesn't route it for approval or send it for signature. Stateful agentic AI can actually do that without any other human instructions, especially if you put agentic AI stateful in a loop. It can go ahead and make several changes, route their approvals, remind people to approve them, send it out for signature. Stateful AI can do all those things. And why does that matter right now? Because many enterprise CLM tools and legal tech tools and fast tools in general have already shipped with agentic AI built in. You may have had a demo or a phone call from your vendor, the sales team recently saying, hey, check out this cool new feature we have. And then you come to understand that it's agentic AI. Lawyers have been approving these tools and using these tools for at least a year, maybe a year and a half. And this definitely will imply or bring into play Rule 5.1 and 5.3. We're going to talk about in a minute, which are supervisory rules or rules applying to attorneys and the ABA model rules for supervising non-attorneys. To narrow the focus a little bit more, we also wanted to spend some time talking about this, what we call the vendor AI problem, which implies one of the other rules we're going to talk about, which is the rule of confidentiality. We all have SaaS vendors. I work for a SaaS vendor and we have SaaS vendors. So your SaaS vendors are employing AI inside the tools. They've already deployed it in some cases, and you may not be aware of it. And those AI applications, especially agentic AI, can bring into play specific regulatory schemes like GDPR and HIPAA. They can also imply your need to pay attention to industry standards like SOC, NIST, ISO that Marlon's going to talk about later. You want to have some assurances both in your contract and in the technical specifications and understanding of the way the tool works about what's happening to your confidential data, because you have confidentiality obligations to your employees, your vendors, your customers, and other stakeholders, maybe even board members. And you want to be aware of what AI is doing with your data, especially the vendors of your vendors. So do you have assurance that the prompts, the documents, the metadata aren't being scraped into public data sets or using or adding to public models? Reminder that you have obligations to your customers, your employees, your vendors by contract to deal with confidentiality and ensure whether, no matter what the tool is or what the application inside the tool is, that you're maintaining confidentiality. There's a forward connection here to the rules we're going to talk about on the next slide from all of these. Vendor AI problem in the difference between agentic and generative AI that we talked about. There are many rules applicable to lawyers and even some to non-lawyers. We couldn't put them all on this slide or in this presentation, so we kind of narrowed the list. And we're using as our sample rules the ABA model rules because many state bars are based on these. And of course, all lawyers are aware of the ABA model rules. We focused on these 4 because we think they're definitely implied or consequential to the use of agentic AI. Rule 1.1 in the ABA model rules for competence, 1.6 on confidentiality, 5.1 on your own supervisory duty managing other lawyers, and 5.3 your supervisory duty with using non-lawyer assistants. Some people might ask, if they're not familiar with the ABA model rules or their own state bar rules, is this really implied by the use of AI, or does use of AI, agentic AI, generative AI, bring these rules into play? One way that the ABA has tried to make this more explicit is by actually issuing opinions. A good example on the rule of competence is the ABA has issued an opinion 512 that states that lawyers using generative AI must understand the technology's capabilities and limitations in a sufficient way to provide competent representation to their clients. So if you're wondering whether or not the rules have kept up, they haven't always kept up, but in this case, the ABA, for example, is giving you an opinion about the application of Rule 1.1 on competence in Opinion 512, published in late 2024, that specifically mentions the word AI. I think you're seeing more and more of that from the ABA themselves, issuing opinions, maybe even changing the rules themselves over time. And lawyers on the call will know that many states, including my home state of Texas, use the model rules to write their own or update their own state bar rules. In 1.6, one of the things we wanted to make sure, we talked about this a little bit earlier, confidentiality. This duty to protect client confidences, we'll talk more about that in a minute with Stas. And the key concept is that you have to take reasonable efforts under the rule to maintain confidentiality. We all know, it's kind of common sense, that includes diligence in evaluating your vendors. Those would be reasonable efforts. Supervisory duties. Many of you on the call supervise other lawyers or non-lawyers, and that brings Rule 5.1 and 5.3 into play. Specific to agentic AI, I like to think of agentic AI as another employee. In this case, instead of being a human worker, it's a digital worker. So you can think about it as an obligation to supervise that digital worker as well. I wanted to kind of bring Stas in here because it's an offshoot. The rule of confidentiality has a couple of offshoots that are important, especially for lawyers. And that would be the idea of attorney-client privilege and attorney-client work product. Stas, tell us a little bit more about how these things come into play in your practice.
Thanks, Lee. So, I think, attorney-client privilege and work product doctrines are two of the sort of highest stakes, issues right now, for attorneys using AI tools to advise their clients, whether you're in-house or you're an outside counsel. Of course, there's the general duty of confidentiality to clients that you need to maintain all of their information confidentiality, but it is also related to ensuring that the way in which you're providing your legal advice and for clients and the way they're seeking legal advice remain subject to those protections. So first, let me take a step back and cover, particularly for those attendees that may not be lawyers, what those two legal theories are. So privilege lets clients and attorneys have candid conversations with each other by protecting those conversations from the obligation to disclose them in a legal proceeding. So, if I'm going to explain all the sort of facts and circumstances to a lawyer when I'm asking for their legal advice, right? You want to encourage that to be as candid as possible. And as long as that's done properly and that's done under confidentiality, when you're in a lawsuit and there's a discovery request, so show me all the documents on this particular topic, or you're in a deposition and, tell me everything you've discussed with your lawyer, you wouldn't have to disclose that because that's protected by attorney-client privilege. A related but slightly different doctrine is the work product doctrine, and that protects attorneys' own work that they're doing in preparation for a litigation from being requested as evidence in that litigation. So whatever the attorney does, the other side cannot request that in the same manner that I've just discussed. And so both of those depend on confidentiality. And as we'll talk about in a minute, that relates a little bit to whether a public AI tool breaks that confidentiality or not. But just being confidential is not enough. And the jurisprudence in this area is still developing. So there's two cases that I wanted to call out. In Hepner, the defendant, who was represented by a lawyer in that case, was using a public AI tool. And the defendant went to the public AI tool and asked it a bunch of questions about the case. That information was obtained by the prosecutor, and the court ruled that when the defendant fed that information into the public AI tool, that undermined confidentiality, and that later, when that information was shared with the lawyer, didn't kind of sprinkle magic dust and make it protected from being disclosed, and the information was admitted. In a different case, the Warner case in Michigan, the court recognized that attorney work product protection still applied to a pro se litigant, and pro se meaning like they were defending themselves when they were interacting with an AI platform, even though that platform was also a public AI platform. So you kind of have these two very different fact patterns, but also apparently, seemingly conflicting opinions, and they're just very early ones. They might be appealed. So, you wouldn't kind of look at those two cases and say you really have enough to go by, but there are a few concepts that you can focus on. So first, recognize that if you're using an AI that is a consumer grade AI under the terms of which the provider can use the data you're submitting to it for any purpose, including training its own models, that can breach the point of confidentiality, and that fact may be then used against you if you're trying to protect information from being disclosed in litigation. It doesn't mean it's fatal, as the Warner case just showed. It may depend on the circumstances, but it will be a factor. And I think your duty as an attorney is to ensure that you're using properly vetted commercial grade tools that protect your data and protect information from being used or disclosed outside the scope. But more importantly than that, I think both for attorney-client privileged and work product, you still need to look at the basics, right? So attorney-client privilege, to bring it back, applies to statements that are made in the scope of seeking or receiving legal advice. So if your clients are going to use an AI tool, even if that tool is enterprise grade and fully confidential, and they're not involving an attorney in that process, that may not ultimately be protected by attorney-client privilege, because an AI tool is not itself an attorney, and the inputs and outputs that are happening in that process may not be treated any differently than notes or any other kind of information that non-attorneys are generating, and all of that may be discoverable. So, be careful, right, as to how you're working with business clients and how you're coaching them to use these tools. Don't get false comfort just because it's an enterprise tool that it will be privileged and confidential, and make sure that, anything they do with those tools that is outside of the scope of the attorney-client relationship, is treated with sensitivity when it's things that may end up damaging in a future litigation. And Lee mentioned sub-processors earlier, and I think that really comes into play with that as well, because most of the tools now are sending the information down to the next level. So understanding like what those who those other sub-processors are, and if those like 1 or 2 level down disclosures are going to risk confidentiality for you is also important, particularly when you're talking about agentic tools, and those agentic tools use things we'll talk about later called MCPs to talk about those tools, and most of those tools have settings inside where you can say, yes, I'm going to allow my tool to like access external search engines or access these third-party services. Maybe it's for transcription and other things. You would need to look at one by one and weigh the risk for each of those. So Leo,
that's really good information, because I think that it helps frame our discussion in terms of the two of the rules we talked about, are the 4 key rules. There's both that duty of competence. Have you adequately and competently evaluated use of AI by your law firm, by any subcontractors, by their vendors downstream? And then the duty of confidentiality, because you don't want to have a tool break confidentiality or put you in a position where you can't claim privilege or work product. And there's a tendency, I think, for in-house lawyers to think of, attorney-client privilege and work product, that's something that I worry about between me and my outside counsel law firm. But it is something that's important for in-house lawyers and even for non-lawyers. So great point of view, Stas. I appreciate you sharing. We wanted to stop here for a moment to give you some takeaways. We have some takeaways at the very end of the presentation, but I think now is a good time before we start talking about standards to give you some takeaways that are directly tied to the rules we talked about. Takeaway number 1, you still answer for AI output that you didn't write and in a system that you didn't build, right? You gave agentic AI, in the case of my example with my NDA, the input, the NDA itself, and you gave it some prompts, but AI wrote that red line for that NDA. And if it's stateful, it may have also sent it off to somebody else in the company to approve or even to get signed. And you certainly didn't build that agentic AI, but you still have a duty of competence to evaluate the use of it, the tool itself, and how it's used inside your organization. And then it may also implicate Rule 5.1 and 5.3, the supervisory duty. Takeaway number 2, confidentiality. We just talked about it. We're hitting it again and again in this presentation, but Rule 1.6, you have an obligation to maintain confidentiality of your client's information, whether you're in-house counsel or outside counsel. And we know now the importance of attorney-client privilege and work product if those are applicable for you in that matter on that deal in your company. Takeaway number 3, an agent that acts on its own, that digital worker I mentioned earlier, is still yours to supervise. You're still the human in the loop, as everyone's heard now many times. And so 5.3 is still important, Rule 5.3, because you're supervising, in this case, a digital worker. One of the things we want to do before we get to standards is also give you a kind of a tool for meeting your duty of competence and maybe your supervisory duty and maybe even your duty of confidentiality. And the way we want to do that was giving you kind of an inward and outward look, a way to kind of look at your organization from an inward perspective and from an outward perspective. So inwardly focused, you're looking at things like governance, training, and communication, probably more things, but in the interest of time, we wanted to focus on these 3, especially the difference between training and communication. With governance, again, applying the rule of competence, you want to have a governance policy that covers AI. You want that policy to be dynamic. So at least quarterly reviews. We like to use a phrase, Marlon and I, is like, who's on watch? So who's watching for changes in case law, like Stas mentioned, regulatory standards like GDPR and HIPAA, and industry standards like SOC and NIST. Someone needs to be on watch. It can be multiple people. But when that person rings the bell to say, hey, this new case law says this, we should be concerned about it, or there's a regulatory change or there's a standards change, that might be an off-cycle time for you to consider changing your policies, cracking open those terms and conditions that you have with the vendors and rethinking them. Training and communication, there are 2 different things. That's why we put them on here in 2 different places. It's interesting that training and communication is sometimes thought of as the same thing. Well, we trained people, so we communicated to them, right? But what we distinguish those, Marlon and I, is training is that a combination of those annual things that we do or those periodic things that we do to kind of tick the box that we've complied with our obligation under our own code of ethics to train people about important issues like data privacy, information security, and now AI. But communication is a broader topic. It's not just the training itself. It's also what are you telling your internal team about the use of AI, about privacy, about information security, and other key things. We update our own team on developments in things like GDPR and HIPAA and SOC and NIST. And so that's the communication piece that's really, think of it, a little bit broader than training. And back to who's got the watch, owner clarity. Who's on watch, not just for those developments in case law or regulatory standards or industry standards, but who's also the person who's going to test, evaluate, and reach back out into the organization to talk to those subject matter experts, the information security people like Marlon, the privacy lawyer, maybe outside counsel. Someone has to be on watch and ring the bell, as I say, to go talk to those other subject matter experts in legal and IT and information security and outside counsel about new AI features that are being rolled out or being considered. I want to mention for just for a moment why an annual policy, kind of set it, forget it, I don't think is good enough anymore. Just a couple of stats for you. Boards of directors and CEOs, 80% of CEOs said in a recent survey, this was 2 months ago by Dun & Bradstreet survey of 10,000 businesses, 80% of those CEOs said AI will require significant changes to their company's operations. So it's on the radar at the top. 90%, 97% of those same people report having at least one AI initiative going on. So CEOs and board members recognize that AI is going to change things and require changes. And 97% of those, so there's maybe a 17% gap there, have some kind of AI initiative going on. 89% of C-level leaders say that agentic AI is a strategic level priority for their company. That's a 2026, also January 26 Content Stack Agentic AI report from 621 leaders from the global 5,000. So is once a year, set it, forget it, good enough for your policies? No, especially not with a rapid change of AI. and how many companies are adopting AI throughout their organization. Stas, I'm wondering if this is something that you get your clients coming to you saying, hey, Stas, we need some guidance. How often should we update our policies? Do we have a template? Should we change the way we evaluate? Should we involve more people? What kind of questions do you get from your clients?
Yeah. So, there was a huge wave of clients coming in for their first round of policies, around the time generative AI first came into scene. And I think, a lot of clients, rushed out and had policies that, basically said you can't use anything without approval. In some cases, just you can't use anything, um, and filed those away. And what we've been seeing now, of course, is the clients that are actually looking, at their governance regularly and updating the policies. They're starting to realize that those kinds of policies are no longer sustainable, right? AI is pretty much inevitable unless you're using a typewriter. It's baked into pretty much every, productivity and office and business suite out there. And it needs to be addressed at a more granular and thoughtful fashion. Sort of flat out prohibitions no longer work. Um, and the last round, I would say, as of this year, is starting to focus on the agentic capabilities and, also anybody that's using AI for development, coding assistance, things like that.
Right.
Some of the developments this year, are really requiring targeted approaches and changes in the way, even people think about their IP rights, because like 80–90% of the code is now starting to get written by AI. So all of that's showing that, yeah, I think a sequence of once a year is the bare minimum. But I would say at the pace things are looking at right now, you really want to maybe even look at it twice a year.
That's good feedback from both sides, because I know Stas has clients on both sides of the vendor-client divide. So we talked about inward governance. Let's talk about outward governance on the next slide. So I think it's easy to just isolate your thinking here and say, so I just need to evaluate my vendors. But I want to add for you to consider holding your vendors accountable. So there is an opportunity for you to reevaluate agreements that you have in place with your vendors, everything from the MSA, the original kind of master terms and conditions, but especially things like DPAs and BAAs. For many of us, if you look at those DPAs and BAAs that were signed up with that vendor 2–3 years ago, they are technically out of date today because they don't take into consideration the development of AI, especially agentic AI, and AI laws from different regulatory bodies. The simplest example is the EU AI Act did not come into force until late last year, and it's coming into force kind of in waves or tranches throughout the rest of this year. Well, if you did your BAA 3 years ago, or you did your DPA to comply with GDPR 3 years ago, it may not comply with the EU AI Act today. And even if it did, we all know that because AI is changing so rapidly and developing, that's great in terms of giving people like me and Marlon and Stas and great new tools to play with and to be more productive. But the pace of innovation in AI is outpacing the regulators. Even I would say the EU, who's pretty up to date, is not keeping up with the development of technology. Another way to think about this, besides just which regulatory standards or industry standards, is also, are you in an industry where it's more important to hold vendors accountable, to reevaluate those terms and conditions because of industry-specific regulation, like HIPAA for healthcare here in the US, GLBA for financial services. If you're in those kind of industries that are heavily regulated, there may already be changes in regulatory standards and industry standards around AI that you need to be aware of, and you need to be trying to bake those into, if you can, agreements you already have in place, but certainly agreements you sign in the future. This is somewhat of a vendor questionnaire, but kind of like that policy that we just talked about on the last page, inward focused, where we don't want to just set it and forget it and say, well, we did it once a year and we trained on it, we're good to go. Same thing with your vendor questionnaire. I think Marlon would agree that it's time to dust off your vendor questionnaire and think about, okay, am I asking all the questions about AI that are tied to information security and privacy issues? Probably not. Probably need to update it. and then send it back out again and get even current vendors to give me an updated vendor questionnaire. And remember that a vendor saying, well, I have contract terms that say AI did it, so that's not acceptable. AI did it, so I'm not liable is not acceptable. There needs to be some risk sharing that you negotiate with that vendor about not just the quality, but also where is my data? Who has access to it? Those ideas imply your duty of competence and your supervisory duty. It's not okay for your vendor to say anything with AI has no warranty, especially if you're paying for that new bell or whistle that's generative or agentic AI. But there needs to be some risk sharing between the two of you. Speaking of vendors, though, and industry standards, I wanted to transition to Marlon to talk specifically about some of the key industry standards and what he sees is their application to AI and how they're changing because of AI. So Marlon, talk to us about these three.
Thank you, Lee. So just to kind of touch on what Lee was just talking about AI governance, it's no longer limited to just regulations such as the EU AI Act or some of the state AI laws. It also encompasses many of our existing standards such as SOC 2 Type 2, ISO 27001, and NIST as well. All of these have have a component that is being added specifically for AI and for the risk and controls as AI evolves. We all have an ethical obligation under knowing which standards apply to your industry and what's changing. So I'll cover a little bit of how these are different. SOC 2 Type 2 is more of an operational control audit. It gives an attestation and tells you how your controls are functioning for a defined time period. ISO 27001 is the information system management system certification, covers the framework for security controls and also has certain scope considerations. It does require certification for that by a certified auditor. And also NIST is a framework that encompasses a control library such as the cybersecurity framework, 800-53, 800-171, and also it shows where those controls fit as far as with vendor diligence. So just to expand on that conversation, as AI security and compliance should not be treated as a separate program. They should be integrated into the existing security, privacy, and risk management and vendor management ecosystem because those governance controls that already exist in SOC 2 Type 2, ISO 27001, and NIST, and already aligned with your framework are critical to the AI security ecosystem as well. So also just to mention, AI doesn't replace the existing security and compliance obligations. It does expand the scope of what must be governed and secured, monitored, and evidenced just because it is unique and it is ever evolving. Some of the core questions you may have for auditors, customers, regulators is, can we prove that AI systems are used responsibly, securely, consistently over time? The SOC 2 Type 2 actually provides that attestation for those controls and answers those questions. ISO 27001 also encompasses that because it actually shows how your program is actually bringing the forefront of actually security controls in regards to your AI platform and your ecosystem as well. And also NIST provides that framework as far as creating a true unified governance system. So just to go into more detail about how these are different and how they actually encompass the effectiveness of AI governance, SOC 2 Type 2 once again does cover their operating effectiveness over a defined period of time. So AI compliance must be supported by repeatable evidence, not just policies. AI fits most directly into the security trust services criteria that is associated with the SOC 2 Type 2 because we must protect systems in the data from unauthorized access, misuse, leakage, and manipulation. Just as Lee said earlier, AI data can be highly interpretable, and it must have, I know we might have mentioned it earlier, the human in the loop, which is that observation by having a real person review the quality of that data. In any instance that AI utilizes customer confidentiality or personal data, it may also affect confidentiality and privacy commitments as well. So some of the key evidence examples in the SOC 2 Type 2 for AI would be approved AI use cases, access controls for AI tools, vendor reviews, data handling rules, and model or prompt logging, incident response records, and periodic access reviews as well. Just as Lee touched on earlier, the once a year set it and forget it no longer applies because the security controls in the threat landscape for AI is ever evolving. Also for SOC 2 Type 2, the goal is to show the AI-related controls were designed, followed, monitored, and improved throughout the capture period or the attestation period. That shows that your program is effectively providing governance. For ISO 27001, it gives us more of a management system structure scope, and it also encompasses the leadership, risk assessment controls, performance evaluation, internal audit, and also continual improvement for your AI programs. AI should be treated as an information security risk area inside of the ISMS, especially where AI systems process sensitive data, support business decisions, or connect to production environments. So this does encompass your vendor surveys and questionnaires as well, which are critical. Important AI-related risk topics also include data classification, access control, supplier management, secure development, logging, monitoring, incident management, and acceptable use cases and policies as well. So ISO 27001 focuses on protecting confidentiality, integrity, and availability as AI adds new scenarios such as prompt injection, data leakage, model misuse, hallucinated outputs, which is when AI misinterprets or reinterprets a query, and dependency on third-party AI services as well. One of the benefits of ISO 27001 is it does help us institutionalize AI security so it becomes part of the normal risk and control lifecycle rather than an ad hoc technology decision. So it doesn't convolute the existing security ecosystem as well. So one of the critical controls within NIST is NIST provides the AI risk mapping into a practical operating model, especially through the AI risk management functions. And those critical mapping models are governance, mapping, measurement, and management. So governance is going to touch on assigning accountability, policy oversight, roles, and decision rights for AI use. Mapping is going to encompass identifying where AI is utilized properly, what data touches, who is impacted, and what risks exist within those use cases. The measurement is going to encompass testing and evaluating risks such as accuracy, security, privacy bias, resiliency, and reliability. The management portion is treating risks through controls, existing security controls, monitoring escalation paths, incident response, and continuous improvement. This overall gives a security and compliance teams a common language to communicate AI risks, even when the organization is still maturing to have a formal AI governance program. So you may ask yourself, how do these three standards fit together? So in every instance, these standards provide an answer to many of the prominent compliance questions, such as the following. So SOC 2 can help answer the question, can we prove our AI-related controls operate effectively over a defined period of time? Because SOC 2 encompasses those defined time periods that show how your controls are functioning, will actually be able to, provide a defensible evidence for how your controls are functioning in regards to your AI ecosystem. For ISO 27001, it will help provide defensible evidence for our AI systems managed through our formal information security management system. And for NIST, it will provide you the defensible evidence for, do we have a structured way to govern, identify, measure, and manage AI risks collectively? So together, these standards provide governance from management system disciplines and also from an audit evidence perspective. Overall, AI security and compliance is not a new compliance universe, but it is the next evolution of security governance. Organizations will earn trust by being able to show clear defensible ownership, approved use cases, and protection of the data and monitor systems utilized in testing the controls for AI. So next we'll cover what I like to say is the things that keep every InfoSec director up at night. So it's the InfoSec director's checklist. So these are just a few things that every InfoSec director, regardless of their industry, may have at the front of their AI, I guess, worry list. So the first item is tracking standards as they evolve. I know Leaf touched on this earlier. So assigning clear ownership, having a name associated in a role that watches AI security, privacy, regulatory, and contract standards, not just a security team, because you have to have someone that is up to date on all of the ever-evolving changes. Recommended ownership. So InfoSec owns the security controls, legal owns the contract language, privacy owns data use obligations, and procurement owns intake gates. The business owns the vendor use cases. Keeping a lightweight standard register, such as NIST AI guidance or ISO or IAC 42001 or CASA questionnaires or control matrices, or OS LLM, risk and relevant sector regulations also will help as well. One of the things that we always say is that if no one is accountable for watching the standards, the checklist becomes stale because it becomes outdated as AI is ever evolving and outpacing the standard. The second item on the checklist is updating the vendor information security questionnaires. This goes back to what Lee touched on earlier, that there has to be more of a proactive approach. So asking what AI capabilities are embedded in the product today and what is on the roadmap. Ask what customer data enters the model workflow, the prompts, the documents, logs, metadata, support tickets, telemetry, and outputs. Ask whether customer data is utilized to train, fine-tune, evaluate, improve, or monitor models, and whether opt-out is default. Many of you may see this on your questionnaires currently. So also asking which models are used for proprietary, third-party, or open-source customer dedicated or shared multi-tenant models. Ask for evidence for SOC 2 or ISO reports, AI control mapping, data flow diagrams, model change management, retention, and deletion procedures as well. This also will give you an indicator of whether or not there is truly a human in the loop when you're actually going through these questionnaires and when you're requesting data from your stakeholders. One of the third items on the checklist is contract additions to require 75 seconds. One of those contract additions is model training prohibition, right? Vendors may not use customer data, prompts, outputs, logs, telemetry, or derived data to train, fine-tune, or evaluate or improve models without explicit written approval. This is critical in a lot of questionnaires because sometimes that question is missed. Sub-processor disclosure. Vendors must maintain a current list of AI-related sub-processors, model providers, hosting providers, and data processing locations. Many vendors may not be aware that some of their sub-processors may have AI components or tools that utilize AI components that are actually logging data or training the data based on the data input for the system. So this is critical for your questionnaires as well. Audit and evidence rights, which is always critical. Require the right to receive independent reports, control mappings, penetration testing, and summaries, and AI governance evidence. Another item is data retention and deletion, defining retention windows for prompts, output logs, embedded telemetry, and require deletion upon request at the end of termination of contractual services. Model change notices, because AI models, whether agentic, otherwise, are changing rapidly. Require notice when model versions change and provide training practices and data workflows as well, and privacy and compliance reliability as well. Also, incident notification, because there are different anomalies as the AI ecosystem from a risk, compliance, and governance perspective is changing. You want to define notification timing and include AI-specific incidents such as unintended data exposure, prompt injection, compromise, model misconfiguration, or unauthorized model access. And one of the last items that I'll say that I want to touch on is some of the critical items that will require you to rerun diligence or perform more due diligence. Annual reassessment of all materials for AI vendors. Immediate reassessment when the vendor adds generative AI or agentic AI workflows or changes their models. Or add new sub-processors, and also cross-border processing. Many global companies right now are having a little bit of a hard time because of cross-border processing as well. Also, event-driven reassessment. So any changes within your vendor security incident management ecosystem or the regulatory changes, and also any major model or version changes as well. So one of the things I want to say in closing in regards to the checklist is the director level takeaway is simple. Assign ownership, update the questions for your questionnaires, and make sure your protections are contractual and rerun diligence whenever the AI footprint changes. The operating principle is that no AI vendor should move faster than your ability to understand what you're contracted for and verify how it handles your data.
If you're in a jurisdiction that requires a verification code, please write the following code word down. Hotel. H-O-T-E-L. Hotel.
So next I'll hand it over to Stas to discuss a little more on how these different scenarios play into the ecosystem with customers. Stas is our special guest, our principal at GTC. Stas, I'll hand it over to you, sir.
Hey, thanks, Marlon. So, yeah, this was a great, I'd say, and very, very complete overview of all the security standards and processes and best practices. But I kind of wanted to step back and also acknowledge that right now, from a purely regulatory perspective, right, very few of these things are like 100% mandated by law. So it's very hard, as a customer, when we're negotiating customer agreements, for us to go to a vendor and say, you very clearly must do all of these things, and if you won't do them, we won't buy your product, right? It usually starts with a customer deciding that this is the best practice. This is what we feel is the appropriate level of protection and diligence and security for our use of the product, and this is what we need. Or it starts on the vendor side from them saying we want to be the best in class and we want to make sure that we comply with all of these policies. So we certainly have some clients that kind of lead with that as a sales point almost and say, yeah, we've checked off like every one of those boxes that you've just discussed. But the reality is often somewhere in the middle. So if a customer is evaluating a vendor for compliance with these things, they may not actually be able to check every single box, depending on their state of maturity, their product, their regulatory environment. And so don't think that just because a particular vendor is like can't check a particular box that automatically disqualifies them and you move on to the next one. I think the right question you would need to look at is, what's the standard that we need to apply to this particular use case and the sensitivity of the information? And where are there gaps, and are we comfortable with taking a risks on those gaps or not? And perhaps maybe, if the vendor is flexible enough, you can work with them on trying to close some of these gaps to meet your particular use case. But it's not always going to be a clean, yes or no, depending on their ability to check every single box. That of course matters more when you're in a high stakes environment. So if you're in a place where there is actually a lot of regulation about what you're doing, for example, in insurance, where, if your models are used like in underwriting policies, there's certain things you have to comply with. If you're in government and there's EOs you have to pay attention to. If you're doing anything with regulated data like payment card data or personal health information, financial data, things like that, there's going to be extra scrutiny, and you're going to need to limit your use to the services that can meet those extra checkboxes. Even if other people can use AI in a more relaxed fashion, and that's where some shared responsibility comes in, which I'll talk about at the close of the slide, because it's really not a one-sided thing. It's not like your AI vendor will be able to solve all of your problems. The way you use the AI and the way you implement the AI has as much to do with it as your vendor. Sub-processors, which we've touched on before, of course, are a big part of that shared pictures. The third and fourth parties that are behind the scenes might cause as much exposure and damage as your, first-party vendors. So not forgetting about those and making sure you have a good understanding and level of comfort about as to what those are. Sometimes you'll see that dealt with in a data processing agreement, but you need to be careful to make sure as the data processing agreement dealing with just personal data, all of your confidential information, because you may have confidential information that is not personal data, and it may technically, depending on how things are worded, fall outside of the DPA, and you may need to deal with them as their own line item. And then So let's talk about for a minute, shared responsibility and MCPs and agentic access in particular, because this is kind of a hot topic. So, um, when the AI first came into the scene, a lot of vendors would put out terms that say, "Hey, this is like crazy new experimental functionality. We don't know what it does. We're going to give it to you for free. You agree we're not liable for anything. Feel free to use it, but it's not on us," right? Now, a few years later, customers are specifically buying solutions that have uh, an advertised set of safety measures, compliance requirements, things like that, right? They're picking vendors much more intentionally. But it's surprising. Sometimes I still see those terms from a couple of years ago from a vendor when you actually go to sign a contract that says, our tool uses AI. We're not responsible for anything having to do with AI. And so that also, of course, doesn't quite work when that's the commercial value you're seeking from a deal. On the flip side, a customer also has some duty to mitigate harmful effects when they're using an AI system. So if you're getting an agentic AI tool that has, completely open-ended access as to using this protocol called MCP, which is sort of think about it as a USB port for AI that can plug into like any number of other tools. You might not even know what those tools are. If they plug into the port, they can talk to the agent. And so the customer gets that tool. It could talk to just about everything, and it's on the customer to configure it, what tools it's going to talk to. And each one of those tools can have data and information that needs to be properly tagged and properly classified and given proper scoping and permissions and credentials. It's ultimately on the customer to make sure that they configure the tool to mitigate those risks. It's that shared responsibility, and the vendor probably, if they wanted to, couldn't mitigate the risk. So like, where do you land on all this? And one possible middle ground we've seen is the vendor um, extends their reps and warranties to cover their documentation as relating to AI. So if they're advertising a particular set of features that are available in the product and mitigating that they work a particular way, then they're repping and warranting that they will work that particular way. But at the same time, also kind of expect that the vendor will say you as the customer also have to configure the tool to use those safety features and not give it access to things that shouldn't be accessed. And of course, you're responsible for the inputs and you're responsible for human oversight of how the tool is used. And because you as the vendor can control it and ends up being, somewhere in the middle, I think is the place where I see this ending up. I think we can move to the final takeaways.
Yeah, thank you for that perspective, Stas. I was going to mention, let's kind of stop here for a moment before we get into final takeaways. I was listening to both Marlon and Stas talk, and I wanted to tie back some of the things they've said to those rules we talked about, the rule of competence, the rule of confidentiality, and the supervisory duty that you have. I think I heard Marlon say something along the lines of confidentiality, privilege, risk management, physical security, multiple times. All those things in the information security standards apply under those rules we talked about. You have a duty of competence not just to use AI competently, but also to competently evaluate your subcontractors. And as Stas said, your third and fourth line subcontractors downstream from your primary vendor. The duty of competence applies there too. And your duty to maintain confidentiality applies. You can't say to your client or to the court, well, it was some fourth line vendor that violated confidentiality, so I'm off the hook. You might have contractual remedies against the vendor or their downline vendors, but you're still on the hook. And then Stas, thank you for reminding me of something Stas tells me all the time when I ask him this question as my outside counsel. You can't just say in your warranty clause, we're not liable for anything. If you use AI, I have no responsibility, no warranty. And by the way, you indemnify me. Those kind of things don't work anymore with agentic AI because I think enough lawyers have heard about agentic AI and have evaluated enough information security addendums and revised DPAs and sent out enough product demos that they know that vendors should be accountable in some shape, way or form. And so there has to be some risk management, some risk sharing when it comes to things like warranty and indemnity in terms of your legal terms around use of agentic AI. And all of those things also imply the rules of confidentiality, supervisory duty, and confidentiality. Let's talk about some final takeaways before we open it up for Q&A. So, Stas, why don't you lead us off with final takeaways?
Yeah, I think first, I would say lead with governance, not prohibition. The age of prohibition is past us. Adoption is already happening, whether you know it or not, and you can't sort of ban your way out of this problem. So having a clear living policy that says what's approved, what's not approved, what are the approved use cases, what kind of data can be used with your policies is really a necessity at this point. And also make sure you don't have a policy that is unrealistic. If all it's doing is setting a bar that you can't meet, then it's potentially just bad evidence in a lawsuit um, against you if AI goes off the rails and now you're found liable. Make sure your policy actually sort of reflects what your real state of governance is. Second, be mindful of privilege and work product, as we mentioned. The moment like the work touches an AI tool without a lawyer, know that you're risking that it may not ultimately be privileged. And so if you're in a legal department and you have clients playing with AI or second guessing your advice or trying to get a second opinion to come back to you and say, hey, see, lawyer, you're wrong. ChatGPT knew better. Just remind them that if you didn't direct them to do that, which you probably didn't, all of that may end up ultimately as producible evidence in litigation. So, train your business users that AI is not their lawyer. You are. Scope agentic and MCP access tightly to make sure it doesn't go off the rails, as we just touched on. And then finally, don't forget about your vendor templates. The default terms, that were good 2 years ago may not quite work. So if you put something in place when generative AI first came on the scene and haven't touched it, now would be a good time to dust it off and take a look and see if that's still working. Is it reasonable, and market at this point?
Marlon, how about you?
All right. So establishing accountability, policies, risk tolerance, and clear oversight structures. So having someone responsible and being accountable for the policies for AI, like Lee and I touched on earlier, just kind of keeping an eye on some of the emerging compliance and governance regarding AI and the different models, and also having risk tolerance internally to your risk appetite as well, your risk culture. Allocating resources to prioritize and respond to the AI security risks identified. So having a dedicated security team, having someone that governs and watches and keeps an eye on your AI governance and your policies, use cases, and your acceptable use standards and policies as well, such as a DevSecOps team as well as your dedicated security leader as well. It's going to be critical. Evaluating AI data output for fairness, bias, transparency, security, and performance against defined goals. So this is part of one of the things I've seen emerging in a lot of vendor questionnaires and a lot of new audit questions as well for controls is how is that data being evaluated? Do you have a human in the loop? What tests are you performing on your AI models as well? And that's the question that also should be utilized to leverage against sub-processors and just and the entire ecosystem to ensure that the right people are actually ensuring that that data output is fair, unbiased, and transparent as well. Over to you, Lee.
So thank you. Human in loop, you've heard that how many times, but I will remind you that human in loop is directly tied to that duty of competence that you have. So if you're a lawyer, you have a duty of competence, but I would also suggest to you that non-lawyers in your organization should try to comply with that, fit their work into that concept as well, that they have a duty of competence to use AI and deliver results from AI in a competent way. And to have that human in the loop, if you're supervising lawyers or non-lawyers, you're also in a way that human in the loop, especially if one of the workers is that digital worker, AI, agentic AI in this case. And then make compliance this ongoing and dynamic thing. When the age of AI, we can no longer afford to have the set it and forget it, talk about it once a year mentality with our policies, with our vendor review and compliance, like Marlon mentioned. Hopefully you're fortunate like I am to have subject matter experts like Marlon for in-house information security and Stas for outside counsel and others in your organization. If you don't, I would suggest that as part of your duty of competence and in your ability and desire to maintain confidentiality, you seek out the subject matter experts, whether they're internal or external, And you're the person who then translates things that people like Stas and Marlon tell you into contract terms and conditions, whether those are with your upstream clients or your downstream vendors. With that, we have time for Q&A, and I think we may have some questions already. Is that right, Emily or Ashley? I can't see any questions.
I think I see somebody with their hand up. If you have a question, just put it in the chat.
Hi, there is a question. I don't know if you guys answered it already. It says, should we be surveying our vendors and attorney/firms as to what types of AI is being utilized?
Stas.
Yeah.
How about that?
Sure. Yeah, I can take it. I mean, first of all, with your firms, you as a client, of course, always have the right to ask your lawyers what AI they're using. Then, the duty of candor applies, and they should be able to fill you in. I would say with law firms, unlike other vendors, because of all the ethical rules that you have already discussed, and assuming you're using a reputable lawyer who you trust, which I'm sure you are, you probably have, a little bit less to worry about, because in order to comply with those ethical duties, any law firm I know is already using enterprise versions of tools with security, reviews, et cetera. But, it's always good to ask and know, particularly if you're dealing with regulated data, and you may provide something more than just, regular contracts, right? If you're like in litigation or you have personal data that's being reviewed, et cetera, you're going to need to worry more about those controls, even with your law firms. And as to your vendors, absolutely. If you're using major vendors, they will already have published a lot of this information online. So they may just point you to the portals and say like, hey, yeah, we publish a list of our sub processors here. You can find our documentation here, and you can go online and check. If you're using smaller vendors, that aren't as mature and don't have as much information available, that may require a little bit more dialogue back and forth between your security teams and your legal teams to really, suss out what they're using. And that's where I think also terms that govern getting notification of when things are changing, or new sub processors or new subcontractors are onboarded to work for you. You need to know that you can govern that through the terms of your contract.
That's good information, and thank you for that, Stas. I wanted to mention that we're over time, so we understand if you need to drop to go to another call or something else. We appreciate your time. If you do need to drop, thank you for joining us. We're going to stay on for a couple more minutes and answer a couple of more questions, but we understand if you need to go, and we thank you for attending. So with that said, I wanted to address one of the questions that I thought that seemed interesting. At what point does over-reliance on the AI tool become a problem? Well, this is great because it ties directly into the duty of competence, right, and the supervisory duty. If you have agentic AI, especially if it's stateful, as I mentioned before, which means you've given it information, prompts, and rules, and it can go and do things for you without checking back or in an automated way, then you're treating it like a digital worker. Another way to think about it is like a junior lawyer or a paralegal that's new to your organization is a digital worker in this context. And have you over relied on that, not keeping a human in a loop, or not having periodic checks for quality of output, or putting in parameters for if it's over $1 million, or if this clause, the identification clause, gets touched even by stateful agentic AI? I don't want that change fully implemented until a human looks at it. So that's where I think you can start to see a brighter line between over-reliance, the right amount of reliance and over-reliance, where you're letting stateful agentic AI take an action for you that really a human should look at because of the legal risk or the dollars involved, or a company policy that you already have in place that says over this amount, 3 people have to look at it. Then you don't want agentic AI to accidentally go around your delegation of authority in this example. Marlon or Stas, do you have any opinion or idea on that kind of when does over-reliance become a problem?
I mean, I'll say one area is in sort of managing people who are just starting out, right? It's perhaps easier to fall into the trap of not thinking about what AI is doing because it just seems so easy. You ask it a question and it presents something that seems so confident polished and everything. And it takes some experience to look under the hood and figure out, well, it looks great, but it actually is not great because it missed, a whole lot of context, or, it's making some assumptions, or sometimes, even the best tools flat out give you the wrong information. Like they still hallucinate. It's still a problem. So,
Right.
I think like, yeah, teaching the people who are just starting out in this profession how to review, like I wouldn't say they should like don't prohibit them from using AI. That's unrealistic, but teach them what to look for and how to review. It's going to require adopting our approach and how we manage people up.
How about you, Marlon? Any thoughts on that?
Definitely. So definitely, I agree with what Stas stated. Also, one thing I want to say is, and I'll give an example for like questionnaires as well. Um, Sometimes utilizing tools that are AI tools just to, answer questions. Sometimes there are unique scenarios, and if you're not familiar with the security controls and how they apply and how they map in some of those unique use cases, you may often trust an AI tool to answer those questions, and without knowing how those controls are applicable and how they're utilized, you actually may trust the tool a little more than necessary, and it may actually incorrectly hallucinate that answer because it's only interpreting the data that it received. Um, so a lot of times, just like kind of like how Stas was saying, that educating those professionals and also educating just that specific audience, such as a new professional to that field or to that specific domain, is definitely critical and necessary. You always got to have a human in the loop for now.
A human in the loop and someone on the watch inside the
Yes,
organization, as we mentioned
yes,
before. Someone has to be on watch for changes in laws and standards that would impact your use of AI and or the need to reevaluate vendors or even change contract terms. So
definitely.
we're out of time. We're over time. Thank you for those who stuck with us. We appreciate it. Thank you both of my fellow presenters, Marlon and Stas. It's great to have you. Thanks for joining us. And thanks also to everyone who supported this presentation. And with that, we're ready to close.